I'm thrilled to have with us Hillary Johns, a civil trial lawyer who specializes in employment law. Do I have that right?
You do. We also handle business and real estate law, though. We do the big three.
Okay, so Hillary's taken more than 100 cases to verdict, which is all the way to a jury decision. And in today's legal landscape, that's pretty unusual. It's really extraordinary to have that kind of record. You're the managing partner of Hillary Johns. You're a trial lawyer with offices on both coasts, Beverly Hills, Bay Area, Manhattan. You're AV rated by Martindale Hubble. I had to write everything down just to get this all right. The highest professional rating for legal ability and ethical standards. He graduated on the Dean's List from Golden State University School of Law. You're licensed in California, New York, and Washington, D.C., and Montana. I want to ask you about that. And then what sets Hillary apart is her deep expertise in employment law, where she represents both individuals and companies. And she's a former competitive ranked soccer player and professional athlete. Is that right?
That is right.
Okay, we'll have to ask about that too. You're fluent in Spanish and give regular instruction on employment law and developments in compliance. You write for national legal publications, work with American Bar Association, providing legal services to military personnel, and you work pro bono for domestic violence organizations. Wow, you have a full gamut of stuff there. So welcome to the podcast. Did I get everything right there on your bio?
You did. You did. Thank
Okay,
you.
fantastic.
You
Let me
did. You
just
did
launch.
right by me, Zane.
Good. Well, it's a lot. It's an impressive background. So, with over 100 cases to verdict, it's extraordinary. What drives you to take cases all the way to trial when most attorneys settle?
Well, I think some cases just have to be tried, and I was extremely fortunate early on in my career. I worked for two firms in particular that were very active trial practices. In the 90s, that was a thing. Now, not so much. Now, most people are saying, "Oh, you're not going to get to trial." You're right. The landscape is very different now. But I see a lot of this with clients, and one, I watched a lot of Perry Mason, and two, I see a lot of clients who are going, "Oh, well, my lawyer tells me I need to do this," or "Oh, I don't know what trial is going to be. It's too scary. It's too much work," and I think they get intimidated by the process, or they don't have a lawyer who is really committed to taking a case to trial. If I'm 56 years old, 57 next month, if someone told me I've had one trial at my age, I'd be like, well, I'm not going to choose you. Whereas if you're at a firm and you find out that your lawyer, what is your lawyer's motivation for not wanting to take this trial? Do they think it's a loser? Do they not want to go to trial themselves? Do they think they don't want to spend the time because it's a lot of work? I mean, there's a lot of reasons that go into that, not just because of those. And a client may not understand their options. They may have seen something or seen someone who's had a bad experience. I get that a lot. My friend told me this, or I heard a horror story, or this happened here, so that's going to happen to me. And so I think there's a lot of misinformation about trials. And I think it's a long road sometimes. It used to be you could get a trial in a year and a half. Now they're setting everything out. Depends on the county. But if you're looking at LA County, the Bay Area is faster, New York is faster. LA is one of the slower counties right now in that regard because we have such a backup, like just downtown, like the Stanley Mosque is, the biggest courthouse in the country. So you have all these judges and like floors and floors and floors of courtrooms, and it's backed up. So I think it's the process, and I have had some cases where I tell them, I go, look, you're not going to do any worse than what they're offering you. There's only an upside for you, so why wouldn't you go? And so once you get into the courtroom and you do these, you're like, okay. But people see things on TV too, I think, and in movies, where there's these and sometimes there are very dramatic, and people are being grilled on the stand and humiliated and torn apart, and it just doesn't always go like that. And so once they get into that, I think that helps.
So, when you're evaluating a potential employment case, or really any case, what red flags make you say this isn't winnable versus what makes you think we can take this all the way to trial?
Well, if a client's not being candid with me, if there are issues with abuse, I would say. We have had instances, and I think all lawyers can fairly say this in business. Not just, I know classically it's criminal, where the criminal comes in and say, it wasn't me. I didn't do that because I was off committing a crime. You know, I didn't murder this person because I was committing armed robbery down across town. You know, that kind of that does happen. And to be fair, I have defended criminals who have said it wasn't me because I was over here doing this. You know, I was getting high in this house or whatever I was doing. But I think those are red flags. Any kind of abuse or misconduct is a red flag to me. And there are clients who really don't understand the law, things like that. But when I'm looking at things getting out of hand, multiple attorneys, if they've had more than one lawyer, I look at that, and it happens. I did have a case recently where they weren't happy with their first attorney, and their second lawyer died. You know, that happened. You know, the kind of thing. It became another one. I have another matter. The attorney just became very, very ill. I mean, these things happen. Or had, just said, look, I told you I'd help you this far. I can only go this far. There are things that happen, but if you have someone as several lawyers, like 5 or 6 lawyers, watch out. More than 2, there may be a problem with the client, and some are just bad luck. I will say that sometimes it's not a good match. I think it's extremely important that whether you don't have to be best friends with your lawyer, but you should feel like you can talk to your lawyer and communicate clearly with them. If you can't, it's not a good match. So I would say things like that. I would say yelling, other behaviors like screaming. I know I'm trained in it, and a lot of lawyers are in trauma and things like that, because as you know, if you ever seen someone who's been in a car accident or saw a violent crime, like for example, or has been a victim in any way, or is getting harassed or bullied, they may be stressed out, they may be screaming, they may be, there could be several explanations that are very reasonable for that. Say someone just died, very traumatic things. That can explain behavior that is not within the norm. But if you're seeing reactions and sort of attacking behavior, this person may be looking somewhere to put all that, whatever it is. And if they're going to put it on you, that's no good. Malpractice claims against previous lawyers too.
So so when you look at the basis of the case, what makes you decide, okay, this one is a winner, this one isn't a winner?
I think what the allegations are. I think that, what the defenses really are, if there's documentation. For example, if you had a harassment claim, which we get a lot of those, harassment or wage and hour are very common. ADA compliance are one. I look at the firm, they do have these, not surprisingly, and when I say this, I want to be clear, I know some excellent personal injury attorneys on both coasts, and I without hesitation would refer to them. They are good people, they are fun, and they're not ambulance chasers. Not every PI attorney is an ambulance chaser. But when employment law got big a few years ago in both coasts, a lot of the PI attorneys moved over and started handling these. So the people you'd see saying, did you slip and fall? Did you have a dog bite? Did you get hit by a car? Kind of thing. All went into employment law. So I look at the firm in part. And it doesn't mean it does or doesn't have merit, but some of these places are mills. There are hundreds of cases that just come through, and they get care. We just settled a matter I can't discuss, but the attorney didn't even know the fact. He was just like, okay, and I'm like, sir, we got a nuisance value thing and settled it, but there are issues like that. So I look at the firm, I look at what position they were in, and also just sort of by feel. When you talk to someone, sometimes you can get a feel of what's going on. Sometimes not. I have seen cases where a person looks totally guilty, like they did it, and they're just nervous, or they're upset, or that maybe they just don't present well. So those kinds of things.
Right. So what's the biggest misconception that people have about employment law, and how do you educate clients about the reality?
I think some people think it doesn't apply to them, and I think some people think it's too complex to understand. And so I see it on the employee side. I've seen that happen where they go, I just didn't know my rights were and I was afraid to ask. I want my paycheck. I need to go home. I need to have a job. Each state has a Department of Industrial Relations or something like that, similar. They can advise you generally of your legal rights. Like some of the things I still see people putting up with in the workplace, they shouldn't. I mean, they're violent, they're hostile, they're abusive. there are laws to protect you, but I think the thought of maybe not having a steady paycheck, how long is this going to take, being stigmatized, or not knowing your legal rights or know where to help, who will help you, is scary. I think for employers, I think there are so many laws, and New York has done a better job than California, I think, because California's just having so many changes. All these, it seems like every week there's a new change for that. But I think New York's done a better job than we have on that. I think sometimes employers think this is just too much for me to even understand what I'm supposed to do. I'm going to have a part-time lawyer here advising me on what to do. But if you get systems in place and have someone trained to look for these, it's very cost effective and it's very doable. You just have to know what they are and be aware of it, and calendar those things. You have to think a bit like a lawyer would, but it does help.
So I have a question. So you've done both employees and employers in disputes. I haven't really been involved in the employee sort of from that perspective, but I was as an employer. This was about 10 years ago, and it was in the state of California, and it was really interesting how the was in a what do they call it, arbitration, and but it was very interesting how the state of California, the judge in this arbitration was actually a judge, did almost discarded the laws and just made decisions basically on the basis of what was being said and not on the basis of the laws. So what's your philosophy on picking sides on whether it's the employer or the employee, and how do you measure that out?
Well, primarily, I want to say first and foremost, every judge is subjective. They all have their biases, and people say, "What's this judge going to rule?" I go, "Different judge, different ruling." We've had cases like this. I had one case where we had 4 or 5 different rulings on similar issues because we kept having to change judges for administrative purposes in the courthouse. I would say we primarily do employer defense. So we don't represent a lot of employees, but we do represent a lot of executives. So like say for someone is a CFO at a company and they want to negotiate a package or there's a claim, then we would probably handle it. But I would say our criteria is the merits of the case, whether it's something, there's caseload and things like that. Where I see the case going, some cases you look at and you can tell this might be something you can resolve pretty quickly. Not always, but you might have a feeling like, this may resolve pretty quickly. We tell them it's longer because, we can't give a guarantee. Whereas is that this is going to be a long drawn out matter. For example, we hardly ever take cases on contingency. But for example, if we had an employee who came to us and wanted that, we could say, you know what, I know a few lawyers in town who are good and they can help you. That this is what they do. Would you like me to email them or give them a call and let them know that you're going to be calling? I'd be happy to say that they're taking on cases. So I think duration, the value of the case, some people want to fight. I've had people come to me and want to fight over less than $500.
Mm-hmm.
And, not understand that my hourly rate is higher than that. And so, and that I have staff to pay. And so, and I think that is one of the criteria I look at, whether that person has I don't want to say common sense because that's not a fair thing to say, but the acumen or the insight to understand that this is a complex process, this is a business, there are other lawyers involved at this firm, other staff, and how much time that's going to take. Because, we get these people literally come and go, I'm taking this to the Supreme Court over less than $1,000. And, that if they have an attitude like that, or they start saying things like red flags are, I don't have any money, I'm broke. Okay, those are people who are not going to want to pay you and are going to nickel and dime you usually. And again, being candid with your lawyer is appreciated, saying, look, I don't know what I can afford realistically, are you the right lawyer for me? But I think those are things you think about. And I think you need to see if there's a sense of fairness by the client, that lawyers expect to be compensated, and so they're not going to just pay, there's the client who keeps the retainer and then never pays again. Mm-hmm. That kind of thing.
So remote work, I want to talk about that a little bit. So it's really changed everything. What employment law issues are you seeing that didn't exist like even 5 years ago, or even 2 years ago, 3 years ago?
I would say employee absenteeism. They're calling it the quiet quit. It really isn't. People holding 2 jobs, 3 jobs, not showing up for work but billing their employer. We're seeing a lot of those. people taking sick days, not showing up. So remote work is great. I work a lot remotely. Most of my colleagues who are lawyers go into the office. They like doing it. We have a few attorneys who prefer not to do that. As long as people are responsible here, we give them a choice. But, the key is sort of if they're responsible and actually diligent. Some people, for whatever reason, need to be in the office and need someone sitting on them. They're not motivated enough to do that. So I'm seeing that as one of the biggest issues here, that employers are requiring people to come back to work in the office. There's bills being passed in California and New York for number of sick days and paid time off and limiting it. California had one a couple years because people were just claiming, oh, I'm sick, I can't come in. And then you're getting a bill for 8 hours of work on a day when they work 3. That kind of thing. What is actual work? Shock and surprise, surfing the net is not work. If it's something for your personal thing, if you're running errands online and shopping on Amazon, responding to personal emails and texts, that is not work. Okay, so it's not really fair to blame. I'm also seeing a lot of wage theft claims by employers now, where they're angry, and I understand both sides of it. There have certainly been employers who have exploited employees. I'm not even going to dispute that. Historically, we know this is true. From the jungle, all the way up to Sinclair and all these other kinds of things. We've always seen that. But on the other hand, you're now seeing sort of a flip where people are feeling entitled to exploit their employer and figure if they're dumb enough to pay me, I'm going to keep doing it, and trying to fleece employers, or not taking pride in their work. This is the legal profession. You're a professional thing. It's important to have a good product and present well and things like that. So I'm seeing a lot of those and a backlash from that and changes in company policies and things, how that's going to work. And I think for a while the pendulum really swung from this dictatorship, really, where employees had no rights whatsoever. You were looking at like 1950s people typing and everybody's quiet, and that was a very stifling environment, to too far the other way, which is expected would change, where people just did whatever they wanted. And I have clients calling saying they just called and said they don't want to come in today. I go, well, if the employee's not showing up, absenteeism is a grounds to fire. No, they just say they don't feel like. Well, I'm sorry you don't feel like it, but I think most people would rather be doing something else. I love what I do. I bet you do too. I really, really enjoy it. I feel very fortunate to be part of the legal profession and get to do trials. But there's some days, I'd rather be doing something else. I think everybody could say that. I don't get up and say I don't feel like it today. I'm not going to do it. And I don't think my clients or staff would appreciate it.
Nor would the presiding judge.
No, exactly. Sorry, Your Honor. I had someone like that one time. I remember they're like, I don't really feel like going. I'm like, well, if you don't feel like going to court, it was a client. I'm like, well, if you don't feel like going, are you ill? No. Okay. Well, you need to be there. I'm going. And it's going to be tough for me to defend you and help you if you don't want to show up. But yeah, exactly. No one works alone. That answer.
So what does the employer do in that kind of scenario where you have a group of employees, some are coming in, some are not coming in? How do you protect yourself and know from employees? So I did see an article recently about, it was an extreme article about an employee that had I think it was 20 some jobs that he had managed to. So it was a national news story. It was really kind of incredible. But how do you, as an employer, how do you protect yourself against that kind of thing without, you don't want to turn it into a nanny state either, because then it's like you're kind of insulting your very valuable employees.
Yeah, who may have a legitimate explanation, too.
Right.
It's there. The thing is, you got to remember with these things, I've seen it happen where someone looks, excuse my language, guilty as heck. and you go, this looks bad, and they had a legitimate, and how often have we seen that? Then the employer has egg on their face and maybe a claim against them. And worse, they violated the trust of someone who could be really valuable and loyal to them for years. So, and those are few and far between, because every employer I've spoken to has said it is so hard to find people who are good, and employees probably too think it's so hard to find a good place. Okay, one, depends. Are they using company property? Are they using a computer that belongs to the, because you do have the right, you don't have a reasonable expectation of privacy if you're using company property. So say, for example, everyone in the office has computers from here. So technically we don't, but we could monitor people if we wanted to, and what they're doing. Two, I think a good way is to ask them to account for what they did today. Okay, you came in and had breakfast. You got in at 8 and you had breakfast and you got back at 10:45. Okay, so you had a 2.5 hour breakfast, and you went to lunch at 11:30 because you were hungry. Okay, I mean, you start to see what kind of work did you do and how long did it take you to do it. And as an employer, you can't ask those things. Two, I think check-ins are necessary. The question is whether you want to have an HR, because in the bigger companies or mid-sized companies, you're essentially having someone sit on these people to do that, and is that going to be effective? You need to have written policies in place and say, look, we expect you to be here working, and these are our policies, not in a threatening way, but make it clear if you have staff meetings and things like that, or if you see a problem, you're not out of line. Excuse me, Trigger wanted to get
Is that
involved.
your assistant?
Yeah, he is my assistant. He's my co-counsel. You're not out of line to say, look, it's come to our attention that some people are billing for hours that when they're not here, or may have, or we've noticed a trend, maybe not here. There's a way to say it politely where you're not pointing fingers. If you have 3 people in the office, maybe not the best way to do it, but say, look, this is something we want you to be aware of. This is a trend, and you make it clear to them. But if you track them and say, look at their work, what did they do today? If they got one memo done in 8 hours, unless it's a very intense research memo like we do have here. I mean, it can take weeks to do one memo here because of the kind of work involved. If you're seeing things like that, but sometimes you have to put them under a microscope and say, what did you do here? What did you do here? Why did you go to breakfast for 2.5 hours? What was the deal with an hour and a half lunch and then personal calls and texts? It doesn't seem like you were really doing much of anything, and I think you have to have a policy about written warnings and documentation. Keep a file and say, look, we're going to discuss with you because you were here for 8 hours, which you were paid for, but you did maybe 2 hours worth of work. You've admitted.
So I want to digress a little bit. So your background as a professional athlete is unique. So first of all, I want to find out what kind of professional athlete you were. Maybe talk a little bit about that. But then how has that experience helped you in the courtroom?
Good questions. I was a professional soccer player for a while, and then couldn't do both and be in law school and do that. So in my early 20s, I played for Ajax, and it was great, and I really valued it. And if I had to do over again, I would do it again, even though it was not easy. I'm glad to be quote unquote retired, and have since gotten into martial arts, which I love. But I still run and do all that. And I coach for a bit with my friends' kids and things like that. I think it's really helped, and I've talked to other competitive athletes who have said that too, because you have a mentality when you go, you block out everything else. You don't really think about what you're doing. You're there to do a job, you're there to do this, you play within the rules, you do all these things, and so I do think it helps with focus, concentration. I see some people and lawyers who are really bothered by other things. Does that make sense? Like extraneous things, like being hassled by opposing counsel or something, but there's always a way to work around it. Like, look, in sports, not every play is going to go your way. It's just not. Sometimes you're going to lose. These are things. So I think not being so afraid of it, but I think really focusing on why you're there. I mean, the only thing that really matters there is making sure your case is presented well to the judge or the jury and making sure things are under control. That's your only job there. Anything else at that point isn't that important. It can be dealt with later.
So what's the most valuable piece of advice that you'd give to business owners who want to avoid some sort of employment litigation in the first place?
Be organized. So get a list of all the possible issues. Wage and hour claims, ADA compliance claims, discrimination claims, any kind of harassment. Make sure that you're in compliance with the local laws. Make sure that you're paying them correctly. Make sure they take breaks. Make sure they get rest breaks, and make sure they get meal breaks, and make sure that they're documented. And document anything in that. And I would have an open door policy. I would say, make sure that there's someone specified in addition to the owner and someone else. Say, look, if you're uncomfortable, if you're experiencing problems, please let us know. And also make sure that they have a reference to the state employment rights website. That surprisingly helps in their agreements. Say if you're having
really?
This is who you can contact. California or New York, each of them have them. And they're saying, because if they say they didn't know your rights, say, well, she even gave you the link here. It does help. And I think it sort of makes employees more comfortable. Look, I have seen plenty of instances where a really good employee is not given a fair shot, or is stifled, or is bullied. And I also seen situations where they've sort of come out of their shell, or they've come into their own a bit in work environments that are supportive. So if you can get that from an employee, it might be a win-win for both of you. But I would say make a list, make sure you follow it, and I would make sure that you sort of calendar it. You know, that you're checking in periodically, because those check-ins are what happens. Sometimes people make a list and they just forget about it. And they go, you know, it's been 3 years. How many times have we done that, right? So
Yeah.
make sure you don't do that. Make sure you're doing it quarterly, and that you have someone who's maybe sitting on you as the owner to keep you accountable. Because when you're busy, everything can wait, right? You know, I'll do
Yep.
it later. I'll get to it. You know, we're all guilty of that. But I think that consistency is important, and conveying that to them, that you want this to be a good work fit. Doesn't mean you're opening yourself up to be taken advantage of. And look, likely as a business owner, there's going to be a few things that don't work out. There's going to be. You're going to have a problem employee. You're going to have a bad experience. Don't let it deter you. There's plenty more good where that could.
So now I'm kind of curious. I'm going to change a little bit. I have a bunch of other questions on here, but I was kind of curious about your defense of gender equity, and how does this align with your employment law practice?
It's really, excuse me, Catherine.
And explain gender equity, because that's like a term everybody says. Well, what is?
Oh, the
I mean,
Gender Equity Network. That is the Me Too Time's Up Defense Fund. I'm one of their attorneys, and I do, but I do think it's helped in the workplace. We represent both sides, as you know. I've had men and women or companies contact me. I've been accused of misconduct. We do a lot of those, and I've had people who are victims contact me. I think it's added a parity, P-A-R-I-T-Y, in the workforce that didn't exist before.
Yeah, not the PAR.
Yeah, exactly, the joke. And I think it's added equity. I do think it's exploited, unfortunately. We've had some of those where, there's the, but I think the equities of, I am very much in favor of meritocracy. And I understand nepotism and all those things, and I tend to hire people I know and things like that because I know and trust them and I have a developed relationship with them. But I do think merit counts for quite a bit, and I do think historically that's not always been the case, whether it's because what state you're from, what gender you're from. So I do like the idea of working within this system to address some of those concerns and some of those abuses. So that's what it means to me. Gender equity means meritocracy. It does not mean, to me, I know some people think that I'm not that far to the left. I'm conservative who likes meritocracy, is what I would call myself. That's someone who thinks that there are things based on merit, and I think as someone who's not traditionally accepted, as long as they're appropriate, does a good job, I think they should have their shot. Mm-hmm. I think everybody should have that. If they worked for it, they've earned it, regardless of who you voted for, regardless of your politics. So that's what that means to me.
Yeah, voting doesn't have anything to do with the law. I think some people get confused about that.
Yeah, they do.
When an employee comes to you, well, I don't know, you're mostly doing employment, so let me skip over that one. You're working with employers. So walk me through what you do for trial preparation in an employment case, or really almost in any case. How do you get ready? Okay, you're getting ready before the case, and you're getting ready right before the case. Since you've been on actually taking these things to trial and all the way to verdict, which is, well, like you said, it used to be a bigger thing, but now it's not as big of a thing. How do you get ready? I mean, emotionally and the actual, getting your hands in there and working to figure out how am I going to present this?
Good question. I think, first of all, if you take on a case that is any kind of litigation, maybe you should have it with an eye towards trial right away, years before it gets there. So if you're waiting, I see this a lot, it's 2 months before trial and the attorneys start to panic because they haven't done anything. So, a lot of preparation early really helps you. You should know who your witnesses are, you should get used to them. And I would say, if you're going to handle a case for trial, as much of a hassle as lead counsel should be taking those depositions. those witnesses, the employee who saw something, or the person who works at the gas station, or the AM/PM, or whatever you want to call it, or Cane's Chicken, something like that. Anybody who's working there who saw this person walk across the street with a gun or whatever they saw, you need to get in touch with them, find them, and get their statements early and their depositions. What I see a mistake a lot of attorneys make, it's good to rely on staff. I see it more in bigger firms, but I see it in smaller firms too. But they're not really paying attention throughout. They're not asking those questions. You should be talking to them like they're starting trial, and you should be getting as much information as you can. You need the good information, and you need the bad information. Because if the bad information is likely going to come out, and you have to be able to discuss it intelligently with your trial, with your client. And I think a lot of things can be set up for trial early, and just leave it for a while. Like if you have a deposition and all this information, and you have a trial date. Say you get a trial date and it's not for 8 months. There's no reason you can't send a subpoena out now, 8 months before trial, instead of 8 days before trial, when you don't even know if you're going to find the person. And sometimes witnesses know things that they just don't want to talk about. And they'll say, well, if you give me a subpoena, I will. So make sure you get those things ahead of time. Make sure you have your evidence. A lot of these people just show up and they go, oh, I have this piece of paper, and they think it's going to get admitted. No, it's not. It's not on the witness list. It's not on the evidence list, maybe for limited purposes. Judges aren't fooling around with some of this stuff. They aren't happy when they see people pulling stuff like that. You need to think about who your judge is and how they run their courtrooms, because you're in there. It's like being in someone's home.
So I want to kind of go hone in on that one thing about the judges. So since have a lot of experience, does that give you a kind of a little bit of an advantage over someone who's younger or maybe less experienced, and the ability to defend your client versus a younger person who may or may not understand how to treat a specific judge because they don't know the...
I think it can. I think it depends on the people involved too, because I do see some judges who are very, very nice saying, this is a young attorney. And I was a young attorney once and had no idea what I was doing, and I always felt like I was going to my boss for the answers. And he's like, just go in and figure it out. You'll just go around. I'm like, okay. And I'm glad I did. It depends on the attitude and things like that too. I mean, I think most judges are sensitive to the fact that there may be a younger, less experienced attorney there. But I do think being polite and doing things like that, I've seen some attorneys completely ham it up in front of the clerks, and it's good to have good relationships with, but they're really milking it. That's a little offensive to me. And maybe they see it, maybe they don't. I would say for anyone who's in the courtroom, just be polite, courteous to all court staff and to the judges, and say, thank you, Your Honor, there's this, Your Honor, but make sure you assert yourself. But judges tend to know, when it's a newer lawyer and not. It doesn't mean they're going to disregard them, though. I've seen plenty of cases where the judge is like, well, the young one's right, so that's what I'm ruling. I mean, I think what's as important is to recognize how busy and overworked most judges are and their staff. And they're dealing with impossible calendars to manage. I mean, really almost impossible. And it's very difficult for them to, our job as lawyers is to really focus on someone's case. You're not going to get that kind of attention from the judge. It's not likely you're going to get it from a mediator or arbitrator this week. But a private judge in chambers, they don't have the bandwidth for that. They've got hundreds of other cases to manage. So you need to be polite, direct, and succinct, and to the point to them. And you need to do what you need to do to make their life easier. And without, maybe they haven't read your brief, or maybe they've done this, but they have an impossible task right now, just given the current state of the courts.
When you, I wanted to hone back in on one thing that you said earlier. It was kind of rolling around in the back of my mind, was the idea that you like to interview all the potential witnesses yourself, because you might be able to get some little piece of information out of it that someone like staff might miss some. So do you think this is a routine mistake that certain attorneys will make?
I think it's a routine mistake that certain attorneys will make, and I think if you're not trying the case, sometimes you don't pay attention. There's also the interpersonal dynamic, being in the room with the person or being on Zoom with them. I mean, I've seen cases where people show up trial, hi, I've never met you, who are you? And they're shaking their hand and they're taking off. I mean, there's no rapport whatsoever. So I think having those things and knowing what you're looking for, and who's to say a staff member may do a better job than the lead counsel at following up on some questions, go, hey, I noticed this and I noticed this. But if you have an inexperienced attorney, it's very likely they're going to miss. 70% of communication is nonverbal. And so I think the problem becomes if they're not adept at picking up on that thing, and the person's looking down or their voice changes or things like that, it may mean nothing. It may mean they're lost in thought. I've been known to mumble when I'm thinking about something. People like speak up and I'm thinking and I'm mumbling, but it's, I think there are, but I think if you're trying that case, you need to develop a relationship with that witness. You need to see how you're going to be with that witness, and you need to see them. And if you're not having someone else take the depo, they're going to how to go find what's the information, and you're not going to see that unless it's videotaped, which is expensive.
So as someone listening who might be dealing with a workplace issue right now, whether they're employee or employer, what's the one piece of advice you'd want them to walk away with from this?
I would say, I think safety is the first thing. Look at safety. That's what I would say. That is the number one thing I would say. Are you being bullied, stalked, harassed? Are you safe to go into the office? Or is it safe to have this person in the office? And how serious on the scale of 1 to 10, for example, is it? Is it that someone's taking breaks too long? Or is it because someone has become increasingly hostile during work hours and after work hours, and they've gone through a divorce and they've been seen at the local bar drinking several nights a week and may have a crystal meth problem and own a gun. There's different, it's with a history of mental illness, for example. I think first look at safety. Is this a safe place for you? What resources do you need? And think about the resources you need. So if you're an employee, do you need not come in the office at all? Can you be separated? Is that even doable with a company? Because sometimes they'll just transfer the problem to another department, but if it's a 10 or 15 person company, that doesn't really say much. I mean, what are they going to do? You're still going to have to deal with them. One of the fatal mistakes I see of employers, and I've heard them do this, go, I'm sure such and such didn't mean it. Let's all go into my office and talk about it. Well, telling someone who's been bullied, victim, or harassed, oh, the bully didn't do it, and you're not really experiencing that. Let's go talk about it. It is just not only illegal, but it is really horrifying to the person. As an employer, you have responsibility, your own safety. Make sure they're not following you home or coming after you, because as the employer, you're a target. Or they're not targeting someone else in your office, and they say, hey, you knew this guy was unstable, and he jumped me in the parking lot, and you knew he was strung out, and you didn't do anything. You didn't call the cops. You didn't do this. You didn't have a safety plan at all. You didn't warn me. I didn't know, that there was a problem. Things like that too. So I think, look, you don't have control if someone shows up at the grocery store and an employee shoots them there, unless you knew something. You don't. But if you know the person's unstable and doing things like that, and showing up at the office, you can call the police. You can get people inside. You can warn them and say, I'm sorry, there's been a problem. We recommend you stay away from it. We can't tell you why. But I would say I first assess safety, because the safety aspect of that is one of the number one plans. I don't feel safe going into school. I don't feel safe going into school, work, place of business, anything like that. If you can ensure safety or take all reasonable steps to do that, you're going a long way towards an employee protecting your own safety and everybody else's. And as an employer, making sure that you're doing saying, look, is everybody safe? Is everybody okay? Not just physically, but emotionally safe. Because as we know with harassment cases, it's the emotional abuse and fear-mongering and all those things that cause problems.
Well, okay, we're going to wind it up on that. Hillary, hang with me for a minute here. I really appreciate you coming on today.
I'm so happy to be here, and I'm loving the background. I want this as like part of my place.
I'll tell you about it as we sign off here.